The Supreme Court is hearing cases that could transform the way we communicate on social media. Welcome to America Uncovered. I'm Chris Chappell. It's Supreme Court decisions season, and you know what that means. Time to open some can of worms. Right now, the Supreme Court is hearing two social media cases that could reshape how Americans interact online. The cases have to do with two laws that attempt to ban certain types of content moderation on social media platforms. And it all started with former U.S. President Donald Trump. Because of course it did. You see, after January 6, 2021, Trump was banned on several social media platforms. In response to Trump's ban, two states passed laws that would regulate social media platforms, and their Republican governors gladly signed them. Wonder who they were? I'll give you a hint. It's the usual suspects. Governor Ron DeSantis of Florida and Governor Greg Abbott of Texas. Both states framed the laws as a way to combat censorship and secure individual free speech. The laws in question are pretty far-reaching. They would prohibit platforms from engaging in certain types of content moderation, such as suspending political candidates and censoring certain news outlets. They would also require platforms to notify users if the company removes or alters a post, compel platforms to disclose how they moderate and target content, and make it easier to sue them. According to Florida Governor Ron DeSantis, if big tech censors enforce rules inconsistently to discriminate in favor of the dominant Silicon Valley ideology, they will now be held accountable. Sounds great. Who wouldn't want to hold big tech accountable? Certainly, these laws are pretty popular among conservatives who often feel they're targeted by inconsistent, biased censorship on social media platforms via deplatforming, demonetization, and shadow bans. Of course, tech corporations, on the other hand, hate these laws. They challenged them in Florida's Moody v. NetChoice and Texas's NetChoice v. Paxton, arguing that they violate free speech. Essentially, they're saying it's their First Amendment right to not respect the First Amendment rights of others on their platforms, since it's their platforms. It's kind of like how you can kick someone out of your business for saying horrible, inflammatory things. Things like, Madam Web was the best Spider-Verse movie ever. I don't care what the Constitution says, get out. Free speech advocates are also concerned about the repercussions of allowing the government to intervene in what social media does or doesn't do. After all, if Florida and Texas can dictate how social media platforms moderate, can the federal government dictate what social media platforms moderate? So yeah, many see this as a pretty big deal. According to the General Counsel with the Woodhull Freedom Foundation, it would be mass chaos if the states were allowed to enforce these rules. Because as terrible as social media can be, I never once thought, you know what would make this better? The government stepping in. Meanwhile, several publishing industry groups, including the Reporters Committee for Freedom of the Press, American Booksellers for Free Expression, and Motion Picture Association, signed a brief saying upholding Texas and Florida's intrusion on editorial autonomy would undermine the rights of publishers of all kinds. Wait, are social media sites publishers? I thought they were platforms. Make up your minds, people. Full disclosure, the Section 230 publisher versus platform debate is a whole other legal can of worms. A lot is at stake here, and there are a ton of things that the Supreme Court justices have to consider. At the heart of the debate is this. Is social media's ability to limit individual users' speech through content moderation itself a form of protected free speech? Do social media companies have the right to curate content? Florida and Texas say no. They argue social media content moderation is a form of censorship that state governments have to step in and stop. Florida Solicitor General Henry Whitaker says that social media platforms are simply in the business of transmitting their users' speech and do not have a First Amendment right to apply their censorship policies in an inconsistent manner and to censor and deplatform certain users. Social media is kind of the new public square, after all. Only one with a lot of targeted ads about MeUndies and sexy singles living in your area, wearing MeUndies. Whether you like it or not, social media has become one, if not the most important place for exchanging ideas. Mainly because if you tried exchanging these ideas anywhere other than on social media, people would think you're insane. Madam Web was the best Spider-Verse movie ever. Sir, this is a Wendy's. According to Texas Solicitor General Aaron Nilsen, if platforms that passively host the speech of billions of people are themselves the speaker and can discriminate, there will be no public square to speak of. That's why both Texas and Florida argue that social media platforms are common carriers, like telephone companies. In the U.S., telephone companies can't go around picking and choosing which calls to allow. They can't drop the call if you say something they don't like. That's different from things that provide curated content, such as magazines and newspapers. Although it would be nice if phone companies block people who call me asking about my car's extended warranty, that's the kind of content moderation I can get behind. Meanwhile, Florida Solicitor General Henry Whitaker argues that the Florida law is not regulating tech companies' speech, but rather their conduct and practices, an area where the government traditionally has more oversight. Florida claims that the First Amendment protects the expression of private entities, but it does not give them constitutional license to selectively silence the speech of those they may host. It leans heavily on the 1980 case Pruneyard Shopping Center v. Robbins, in which the court upheld a mandate that a shopping mall must allow pamphlet distribution on its property since it served as a public square. Tech companies, however, have a very different take. I'll tell you theirs after the break. Welcome back. Florida and Texas argue that when social media moderate content, that's censorship. But some say it's one thing for the government to restrict speech, but a whole other thing when a private company does it. Some believe moderating speech on social media platform is a matter of private editorial discretion, not government compulsion. From their point of view, it's a First Amendment violation to force social media platforms to say anything goes. They have a right to moderate what is posted on their platform. Many libertarians, like the Cato Institute, side with big tech in this case, saying Americans have a First Amendment right not only to refrain from speaking, but also to refrain from printing, funding, disseminating, staging, selling, or otherwise facilitating or supporting the speech of others. And guess what? The Biden administration's siding with big tech companies on this as well. Back in August last year, the U.S. Solicitor General argued that the platform's content moderation activities are protected by the First Amendment, and the content moderation and individualized explanation requirements impermissibly burden those protected activities. She reiterated those points during the Supreme Court oral hearings, though she urged the court to reject other arguments made by tech industry groups, including that the justices should weigh in on the law's broader transparency requirements. The U.S. Solicitor General argues that the government has the right to address concerns about social media through other means, such as antitrust and privacy regulations. Because if there's one thing you can rely on the government to do, it's hold giant corporations that give their campaigns massive donations accountable, especially when it comes to privacy. The U.S. would never tolerate an organization spying on its citizens. According to NetChoice and the Computer and Communications Industry Association, which are representing tech giants such as Meta, Google, X, and Amazon, laws like the one Florida passed interfere with free speech by forcing websites to host political content they might otherwise remove. NetChoice argued in a brief that when it comes to the First Amendment, then Twitter's decision not to publish tweets by former President Trump is every bit as protected as Fox News' decision not to air an interview with him. Tech companies lean heavily on the 1974 Supreme Court case Miami Herald v. Tornillo. In that case, the court sided with the Miami Herald after Florida tried to force the newspaper to carry op-eds it didn't want to publish, even though a paper as big as that had a lot of sway over public discourse. The Tornillo decision held that a news outlet's choice of material to go into a newspaper constitutes the exercise of editorial control and judgment. It has yet to be demonstrated how governmental regulation of this crucial process can be exercised consistent with First Amendment guarantees of a free press. It's a difficult balancing act. You don't want the government controlling what the news can and can't say, but you also don't want news media with millions of readers and viewers distorting the truth with their biases, like demanding more pictures of that no-good menace Spider-Man. As Lawfare puts it, the platforms argued that just as the Supreme Court determined that the government cannot compel newspapers to publish replies authored by third parties, the government cannot compel platforms to host third-party generated content. Content moderation, they argue, is just a form of editorial discretion. Tech companies have other concerns about the other parts of the laws as well. They worry about how Florida and Texas might force them to change how they operate to avoid legal threats. They also complain that it's just too much work explaining to each user why certain accounts or posts are removed, although they certainly managed for Trump. The Supreme Court has yet to make any final decision. So far, they've just asked a whole bunch of questions. Questions like, how would non-social media platforms such as Etsy, Uber, and Gmail be affected? And are algorithms considered speech? Are they in the same category as the editorial discretion of newspapers? If algorithms are speech, then I should be able to sue them for harassment, for bombarding me with all those ads about sexy singles and MeUndies in my area. I'm just trying to wish my aunt a happy birthday. Leave me alone. Legally, social media is a pretty murky area. Supreme Court justices note that social media platforms play many different roles, since they have multiple functions such as public posting and private messaging. Some functions are more similar to telephone providers than tech companies would like to admit. Other functions, not so much. Some people only use social media to stay in contact with old friends and never post publicly, while other people literally can't survive without telling everyone what they're doing at all times. You're not an influencer, Haley. You're a validation addict. It's possible the court might just kick the can down the road by letting lower courts sort things out for them. But it seems like the Supreme Court is leaning towards seeing Florida and Texas's social media laws as violations of the First Amendment. As Chief Justice John Roberts points out, the First Amendment restricts what the government can do, and what the government is doing here is saying, you must do this. You must carry these people. You've got to explain if you don't. That's not the First Amendment. Now, even if state governments shouldn't have a say in dictating social media companies' free speech, that doesn't mean that there aren't legitimate concerns about the impact that big tech elites have on public discourse. Trust me, as someone who is frequently demonetized and possibly shadow banned, I get it. Many free speech advocates, like the Foundation for Individual Rights and Expression, which isn't a fan of Florida and Texas's social media laws, are also critics of big tech censorship. I mean, editorial discretion. It's just that they don't see state intervention as a solution. And maybe it isn't. It's especially concerning when the government uses social media platforms as proxies for censorship to get around the First Amendment. And that's why people should especially pay attention to the Supreme Court's take on whether the U.S. federal government overstepped its bounds when it asked social media companies to remove what it deemed to be COVID misinformation. That will be the subject of the 2022 Louisiana case, Murphy v. Missouri, hearing on March 18th this year. Although the more I read into it, the more I come to the ultimate conclusion that social media was a mistake. Except for YouTube, of course. Like and subscribe. Perhaps it's not the government's role to dictate whether social media platforms should stop censoring content they don't like. But that's where people like you come in. As you probably know by now, I've struggled to talk about whatever things YouTube's algorithm considers too controversial. So I've been getting around that by hiding controversial topics in gaming content on my new show, Deep Thoughts While Gaming. Check out the latest about why you need to stand up to evil even when it's not very comfortable or convenient, according to the indie game Dredge. And America Uncovered couldn't continue without your support, so hit that orange button to support the show for as little as $1 an episode on Patreon. You can also set a monthly limit. Once again, I'm Chris Chappell. Thanks for watching America Uncovered.